Hello viewers and welcome to InfoGist TV. Currently, there are fears the seemingly political crisis in the state might boil over after the opposition sides announced plans to hold rallies. Now, the dust raised by the contradiction contained in the certified true copy CTC of the Court of Appeal judgment in the Kano state governorship election has yet to settle, as Chief Wole Olenipekun SAN counsel to the Kano state governor Kabi Yusuf has insisted that the appellate court cannot correct what it claims to be mere clerical errors contrary to the court's position. Olanipekun said that the appellate court lacked the power to effect any corrections in the state judgment, having become functus officio in the case. There are fears that the seemingly political crisis in Kano State in the aftermath of the CTC discrepancies might boil over on Saturday, as stakeholders of both the All Progressive Congress APC and the governing New Nigerian People's Party NNPC in the state announced plans to hold separate rallies in defense of their differing positions. In a related development, a 3-member panel of the Court of Appeal reversed the sack of Governor Abdullahi Sule of Nasarawa State. The appellate court had, in a statement, unanimous judgment delivered on November 17, dismissed Yusuf's appeal against the ruling of the Kano State Governorship Election Petition Tribunal, which had sacked him for lacking merit. But in the CTC release to lawyers, the majority judgment delivered by Justice Moore and Ibrahim Adumain in one breath gave judgment in favor of the appellant, and in another favor, the first respondent, which is the All Progressive Congress. Adumain had read in the open court that the appeal lacks merit and is hereby dismissed. But the CTC reads, in part, that the judgment of the tribunal is set aside. The contradictory positions led by both parties to claim victory at the appellate court, while Deputy Chief Registrar, Court of Appeal, Kano Judicial Division, wrote to parties to return the CTC for correction. The Chief Registrar, Muhammadu Bangari, noted that the errors in the CTC would be effected once parties brought a formal application to that effect. Bangari also stressed that the errors did not in any way invalidate the judgment of the appeal court. But Olanipekun pointed out that the appellate court lacks the powers to effect any corrections in the judgment, having become functus officio in that case. In a letter to the Deputy Chief Registrar dated November 23, 2023, and entitled Retrieval of the Certified True Copies of Judgment in Appeal Number CAKNEP Government Kano 34 2023, Abba Kabi Yusuf and All Progressive Congress and others, the lawyers stated that the appellate court was since in November 18 relieved of any authority to act on the judgment. Olanipekun said the 60 days allowed by law for the appellate court to hear and determine the appeal expired on November 18, and as such, the court no longer had the power to correct any perceived error in the judgment. He also stated in the letter that as officers in the Temple of Justice, we believe we owe the institution, as well as the respected Court of Appeal, a duty to highlight and address some very pertinent issues arising out of your said letter, including but not limited to timely disposal of appeal. The judgment of the lower tribunal was delivered on the 20th of September 2023 by the imperative of Section 285 sub 7 of the Constitution of the Federal Republic of Nigeria 1999 as amended. The Court of Appeal had only 60 days to hear and dispose of the appeal arising from the judgment of the tribunal. Most humbly, the Constitution applies the word within and not from the date of the delivery of the judgment of the tribunal. Constitutional mandate further to the above, the Court of Appeal, by the same constitutional dictate, had up until Saturday, November 18, 2023, to hear and dispose of the appeal filed by the appellant to the Court of Appeal against the decision of the Governorship Election Tribunal sitting in Kano State. Currently, several judicial precedents of the Supreme Court and the Court of Appeal itself abound in our law reports on this subject, which has now become trite. The functions of the court, assuming without conceding that the judgments had some errors, whether typographical or otherwise, will humbly and dutifully draw your attention to the fact that the Court of Appeal became functions official in the matter on Saturday, November 18, 2023. Also, the later added, an application for correction of errors can only be entertained by the Supreme Court by the provisions of Section 285 sub 7 of the Constitution of the Federal Republic of Nigeria, earlier referred to, becomes very handy and imperative to the effect that the Court of Appeal cannot take any further step in the appeal or subject after the expiration of 60 days as provided by the law, and referencing Bangiri's assurance that the error did not in any way invalidate or change the findings and conclusion of the appeal court, and that the error would be rectified once parties in the matter filed a formal application to that effect. Olanipekun also pointed out that they were not aware that any of the parties had filed an application to correct any errors. These thus raised by the contradiction contained in the certified true copy of the Court of Appeal judgment in the Kano State governorship election has yet to settle, as Chief Wole Olanipekun SAN counsel to the Kano State Governor Kabi Yusuf has insisted that the appellate court cannot correct what it claims to be a mere clerical errors, contrary to the court position that there are times stipulated by law for correction and that time has expired, and so the Court of Appeal is now functions official to that effect, which means that they no longer have any hand